Depositions in Massachusetts, and do personal injury cases settle after the deposition of the plaintiff? Short answer is yes, but it's not a definitive answer. Good afternoon. I'm Neil Burns. I'm an attorney along with my partner, Roshan Jain. We practice here at 6 Beacon Street in Boston, Massachusetts, and I've been here since 1987, representing victims of motor vehicle accidents and legal malpractice and all types of accidents where people are injured. And in many of those cases, whether it's legal malpractice or personal injury, the case will settle after a deposition. But why? It's not because there's a deposition. It's because we've set it up properly, because the system helps if you represent your client effectively. So if you can't settle the case before filing suit, for whatever reason, you put it in suit. And the first few things that happen are you serve the complaint, you file the complaint with the court, you serve the complaint on the other side, and the insurance company hires an insurance defense attorney, and you serve interrogatories, admissions, and requests for production of documents. You get the information that they have. Sometimes there's witnesses, sometimes there's documents that are helpful to your case or harmful to your case. You get all that, and you take the deposition of the defendant. Let's say it's a motor vehicle accident, so it's the driver. In a legal malpractice case, it might be the attorney. In a landlord-tenant case where someone's injured, it would be the landlord, or maybe the supervisor, the manager. In any event, you get the information and then take their deposition. You ask them questions. What do they know about this? What do they know about that? How much time went by between this and that? In a car accident, how many seconds went by between this incident and that incident? How fast were you going? Things of that nature. You get a lot of information. And then the critical time for your case is when you respond to discovery. So we produce documents, typically medical records. We answer questions, typically interrogatories signed under the pains and penalties of perjury, and we help our client organize their thoughts and put in their medical history and the sequence of events in the case and the accident that caused their injuries. Then comes time for the deposition. We prepare our clients for the deposition. We prepare our clients for the deposition. So many times I hear from clients or people on the other side, they never even met with their lawyer before, or they were assigned a lawyer by this TV defense firm or TV plaintiff's firm that they just got this lawyer and they walked in for the deposition. We spend a lot of time preparing for a deposition. We know the types of questions that they ask. We know the types of questions that they are definitely going to ask, the types that they may ask. We know how long certain law firms go with these depositions, how many hours. But we prepare our clients thoroughly. We want our client to say afterwards, as one client said to me, you know, Neil, we spent over an hour preparing for such and such, and they didn't ask any questions about that. Do you think that's sort of a waste of time? And I said, yeah, fortunately, you don't have to pay for that time, but fortunately, we were prepared if they did, because you had a lot of inconsistencies in your prior answers to interrogatories and statements you made. So if you have been injured in any type of case, legal malpractice case, personal injury case, car accident case, give Burns and Jain a call. We're very experienced, and we know how these depositions work and what to get out of them so that your case will settle after the deposition. So many of them do, but you have to set it up right. You have to be prepared. Thank you. Call Burns and Jain for a free initial consultation, 617-227-7423. Thank you.